Welcome to the first episode of Called to the Bar, International Law Over Drinks, a series of casual conversations about current issues in international law, life in academia, and whatever else is on our mind. In these conversations, we're speaking off the cuff and without benefit of footnotes, and nothing we say should be taken to have been thoroughly peer-reviewed. I'm Douglas Guilfoyle, Professor of International Law and Security at UNSW Canberra, and this evening I'm joined by Dr. Juliette McIntyre, lecturer in law at the University of South Australia and a star of screen and airwaves when it comes to commentary and analysis on current cases before the International Court of Justice. Juliette, good evening. First question, what's your drink?
Good evening, Douglas. It is so nice to be here. Okay, so my drink is a Dalwhinnie 15-year-old Scotch, which is not my usual tipple. I'm a big whiskey drinker, but this one I'm more of an Islay girl, so this is a little sharp for me. But still, it's doing the job quite nicely. What are you drinking?
I'm drinking a 2022 Clare Valley Chardonnay, which is treating me rather well.
Excellent choice. Very good.
Okay, so I'd like to begin each of these shows with a little bit of background about our friendships and career paths. So frighteningly enough, you and I have been friends for at least 14 years and are godparents to each other's firstborn children. Would you like to tell your version of how we met?
I'd love to, because this story is a tremendous embarrassment to current me. It's sort of a friendly advisory, I suppose, to junior academics that it's okay if you make mistakes early in your career, because they won't necessarily always come back to haunt you and can end up working out very well. So the way that Douglas and I met was I was working for James Crawford at the Lauderpack Centre for International Law, and I was sort of blithely tossed an article by James and said, oh, look, could you read this and give some feedback on it for me? And the article was about the blockade in Gaza, funnily enough, and the Mavi Marmari incident that occurred.
Yep, 2010.
Yeah, 2010, that's right. So, God, that was a long time ago. So what happened was I took to this with some gusto and informed the author, whose name I did not know, of all of the reasons that I disagreed with some of the points that they were making, not least of which was the status of the conflict as an international or non-international armed conflict. I think I put in one of the comments essentially, look, Israel is fighting with someone and that someone is not Israel, so who is it? Anyway, Douglas was extremely gracious about those remarks. And then we literally bumped into each other in James's office, I think, in the centre. And you sort of kindly said, oh, hi, I'm Douglas, the person whose article you commented on. And I went, oh, God. But it went okay. It went okay after that point.
It went more than okay. Well, obviously, as you know, a friendship sort of blossomed thereafter, and we and our spouses have hung out a lot. But I mean, in no way was that a mistake. Like, you know, you actually gave me more detailed feedback than the sort of allegedly full-time academic peer reviewers, one of whom basically said, yeah, this is fine and ready to go. And you raised several points, which definitely strengthened the whole piece. And yeah, I mean, everything comes round again in terms of active international law issues, particularly on Israel-Palestine, which we will be coming back to. But look, I mean, that touches on kind of the start of your international law journey in a way, working for James Crawford in Cambridge. But a number of our listeners are probably just starting out in academia or trying to break into it. So I think it would also be great if you could talk a little bit about how you got into international law and the career path that's brought you to your current job at UniSA.
Yeah, so yeah, it's funny to sort of talk about James because he really was obviously very critical in my getting into the field. But I took international law when I was an undergrad student at Flinders and I loved it. And I took human rights law and I took all of the international law type of topics that you could get at. I even did the lax space moot, you know, anything that touched on international law. I just loved it. And I thought it was fascinating because it had all of these philosophical dimensions to it and these political dimensions to it. It was really law that operated at so many different levels, both practical and intellectual. But I'm from Adelaide, right? So I was like, there is no international law happening in little old Adelaide. I am a not directly a first gen. My parents went to teachers college, so they kind of went to university, but not really. And so, all of these ideas about going off and doing grand things with international law, it seemed very far-fetched for me. I happened to be dating someone who was clever, and I encouraged that person to go study overseas as a way of also perhaps getting that opportunity myself to do things that were interesting overseas. Anyway, so my husband, Joe, everyone who follows me on Twitter will know who he is. He got into Cambridge, and I just kind of blithely followed him over there going, this is going to be fun, but with no plan whatsoever. And in fact, I had qualified as a lawyer and I practiced in like just commercial litigation before we left, but I had no grand ideas about what I was going to do. I ended up working in a shoe store, right? There was no jobs that I could get. The shoe store was great. You get 50% off the shoes. I loved it. What then happened was that I said, I'm kind of bored and I need some intellectual stimulation and I want to get back into legal practice in some form or another. And I sent an email to the Louderpack Centre for International Law and I said, look, I have this CV, I have this training and experience. If anyone happens to need a research assistant or wants some aid on a project, I'll do anything, basically. And the person who happened to answer that email was James Crawford, of all the people, saying, we have a case actually right this minute, which we have 2 weeks to prepare pleadings on. Could you come and help? And it was very fortuitous because I had worked in litigation. So doing pleadings in the course of 2 weeks, that was one thing I could do. I didn't know anything about the area that we were working in. I didn't know anything. It was an ICSID case, right? So an investment treaty dispute. I didn't know what ICSID was. I'd never heard of it before. I didn't understand a lot of the applicable law, but I could write pleadings. I had basic lawyering skills. And from there, James and we got along very well on a personal level. The Adelaide thing was obviously like a jumping off point for like bonding. And it built from there. And I went, actually, I could do this. I'm interested in this. I should apply to the university to do my master's degree and learn more about this. And it just kind of grew. But this is a very long, probably pretty boring way of saying life is very full of twists and turns, right?
Absolutely.
And you don't know what is going to be the moment that changes your career trajectory. So I always tell my students now, it's great if you are passionate about this area and there are certain things that you can do to obviously boost your CV and get yourself out there. But even if you don't know exactly what it is that you want to do and you just have a vague sense that you're interested in these kinds of things, just pick the next best option that's available to you at the time. And you'll be amazed at where you end up after you've taken a good number of steps on that pathway.
Yep. No, I mean, a couple of points out of that. I forget who said it, but someone was, I heard some great career advice once, which was everything makes sense in retrospect.
Mm-hmm.
So, it's not that everything happens for a reason, but when you get to a point in your career, you can look backwards and go, oh, okay, I acquired these skills and this experience, and it adds up to where I am now. And there was no way to plan for that ahead of time.
No, that's right.
The other thing is, I mean, James was my PhD supervisor. So for anyone who doesn't know the name, James Crawford was the late Australian judge of the International Court of Justice, greatly missed. And before that, for many years, Whewell Professor of International Law at Cambridge, but began his legal studies and university career in Adelaide, which is also home to a large number of particularly great figures of law of the sea, like Daniel O'Connell, who wound up at Oxford, and also the late Ivan Shearer. So while you say not a lot of international law happening in Adelaide, I get why you say that, but you actually look at the people who've come from, this relatively small, beautiful city in South Australia, and it's, to use the horrible overused Australian expression, it's really punched above its weight on the international stage.
Must be the fluoride in the water or something.
Or the delicious regional wine. Okay, look, let's move on to our main topic this evening. And so we've already foreshadowed that we're going to be talking about Gaza, and the conflict in Gaza has obviously shocked and horrified the world. So as lawyers, we both consider it self-evident that Hamas is a terrorist organization. It commits what are self-evidently terrorist offenses and war crimes, such as indiscriminate attacks on civilians and hostage-taking. In this context, whether it counts as a national liberation movement is irrelevant. It doesn't matter how just you think your cause is, you're still bound by international law. Now, obviously, that goes for Israel's conduct of the war as well. Democracies don't get a free pass on compliance with international law because their adversaries are using human shields. As the High Court of Israel said in 1999, at times, democracy fights with one hand tied behind her back. Now, with those preliminaries out of the way, events at the International Court of Justice and the International Criminal Court relating to Gaza have obviously captured the international law world and the world's, in the greater sense, attention in recent weeks. So, Juliette, you've been tracking very closely proceedings brought at the International Court of Justice concerning the conflict in Gaza, particularly the case brought by South Africa against Israel under the Genocide Convention. So we've just had the, I believe, fourth application for provisional measures ruled on. And for about all of 30 seconds, the initial media commentary claimed that the ICJ had ordered a complete ceasefire in Rafah. Then everyone started arguing about a comma. Then everyone started saying events have completely overtaken the order. So my broad question for you is, what the hell is going on?
Yeah, absolutely. Look, I know that a lot of our listeners are going to have a pretty good grasp on what's been going on, but I want to just track this whole process. So, I mean, we go back to January and we have what sort of surprised a lot of people, which was this application from South Africa accusing Israel of committing genocide in Gaza. And we're now, almost to June. So it's like 6 months of litigation that we've had on this issue. And the initial order that the court handed down for provisional measures was essentially that it considered Palestinians have a right not to be subjected to genocide, and there was a risk of irreparable harm to that right should the actions of Israel continue the way they had been continuing. But the court didn't order a ceasefire. And there were various reasons that we speculate that that might be, including the fact that obviously South Africa, having brought the case, it doesn't have jurisdiction over Palestine or Hamas. And so it couldn't order a full ceasefire. It could only order a sort of one-sided ceasefire against Israel. That is, Israel, stop what you're doing, but it couldn't tell Hamas to stop doing what it was doing. So it took this sort of balanced approach, if you will.
Sorry, just on that last point, because Hamas wasn't a party to the case, because it can't be, because it's not a state.
Exactly. But even if you had, that's right, like even if Palestine was a party to this, you couldn't order Hamas to do anything, right? Like Hamas is separate. So what the court did was say, look, Hamas, we really think you ought to release the hostages. That would be a really great thing to do. It's very terrible, the things that you have done, but it couldn't order Hamas to do anything. And then for Israel, it said, look, you need to abide by the Genocide Convention. The Genocide Convention is paramount. You need to ensure that humanitarian aid is reaching civilians, even while you're conducting your military operations. Since that time, we've then had all of these additional applications and orders. We had one in February that was rejected. We had one in March where the famine situation became much more acute in Gaza, and the court considered that that amounted to new facts that were sufficient for additional orders. But the orders kind of built on the previous orders. It was like more about making sure that aid agencies could get into Gaza, making sure that food could be distributed and that sort of thing. Then we get to May and we have this announcement that there's a ground offensive planned for Rafah. Rafah being where all of Gazan citizens have been told to go because that's the safe place to go to. So South Africa brings this new application and it says, right, we have to have a ceasefire order. And it was very much in those kinds of terms. The application was super, it was all, I don't really know how to describe it, but it was a good bit of advocacy, but it was also really playing on the sort of moral, almost personal aspect for the judges, like saying this is now or never. If you don't order a ceasefire now, it's going to be too late and you will have failed to act. And, history will judge you kind of thing. Like it was this really passionate piece of writing that South Africa submitted. And we'd already seen that some of the judges in their separate opinions had said, it's pretty hard to ensure humanitarian aid is getting in while active military operations are occurring. So probably we ought to have ordered a ceasefire. This time around, we got a ceasefire order on the fourth attempt, but this is the problem, right? You mentioned the comma. So the order specifically says Israel shall immediately halt its military offensive, comma, and any other action in the Rafah Governorate, comma, which may inflict on the Palestinian group in Gaza conditions of life that could bring about its physical destruction in whole or in part. And so that second comma, as well as the use of the word may, caused everyone to sort of go, oh, was that a full ceasefire order? Like, are they ordering Israel to immediately halt its military offensive full stop? And also other actions that could impose the conditions of life that could bring about physical destruction in whole or in part? Or is it only stop your military action to the extent that it can inflict on the Palestinian group conditions of life, et cetera, et cetera?
So just to underline the really obvious point, you can either read the comma as kind of disjunctive. We've got these two different clauses, one of which says there must be a ceasefire, and the second says, and also you shan't do these other things if they risk bringing about conditions of life that could destroy the group in whole or in part. Or you can wind up reading everything after the second comma as a qualifier applying to the rest of the order, which is everything is limited by this idea that, in a sense, you can do anything so long as you're not inflicting conditions of life that may bring about the destruction of the group in whole or in part. Okay, that, I mean, you know, lawyers argue about commas a lot. That seems a fairly obvious potential drafting issue. We've had 15 judges of the ICJ all look at it. It's not there by accident. So what's your thesis as to why that comma is there?
Yeah, so my thesis is that it's there on purpose, but that actually there is a deliberate ambiguity here. So what I think is that we've seen at least 7 out of the 15 judges indicate that they believe some kind of ceasefire order ought to be made. So we know we didn't have a majority, but we had close to a majority. There were clearly a few judges who were concerned that a general ceasefire order perhaps went outside the scope of the court's jurisdiction, remembering, of course, that we can only address questions of genocide here. It's a genocide convention case. The court can't make any orders about IHL, it can't make any orders about war crimes. So it's quite possible that there were a number of judges who said, look, a general ceasefire order here might step outside the bounds of our jurisdiction. If, however, we tie the ceasefire order closely to Israel's obligations under the Genocide Convention, which is not to inflict on the group conditions of life, so on and so forth, then that's okay. So my theory is that this ever so slightly ambiguous, or in fact extremely ambiguous language was utilized deliberately as a way of getting as many judges across the line as possible. The judges who are pro-ceasefire are able to say, look, okay, good, we're getting some kind of ceasefire order, that's fantastic. The judges who are perhaps more on the fence, Judge Nolte might be one of those. I don't know, right? Like this is not, I have no inside ear to the Peace Palace. This is not.
Yeah, it's all criminology.
Yeah,
we're looking at the documents that come out and trying to guess about the internal deliberations.
That's right. But based on his previous statements in these orders, you know, it suggests that his position has shifted a little bit. So he might have been one of the judges who they kind of needed to convince. So this is my thought, right? That they've put this drafting together, which has this plausible deniability in it, right? Because when you get down the track, when we get to the merits of the case, it wouldn't be impossible for South Africa to say, by continuing its military offensive in Rafah at all, Israel has breached this provisional measure. And it also wouldn't be implausible for Israel to say, yes, we continued our military offensive, but we made sure to do it in a way that didn't inflict conditions of life that could bring about the physical destruction in whole or in part of the Palestinian group. So it sort of gives both parties an out. And it's like I said this in a blog post, but it's like the court is just kicking the can down the road, right? Like, just, I'm going to deal with this at the merit stage, deal with it later. I feel like the court was really under pressure to order some kind of ceasefire. And so it really worked hard to come up with a version of a ceasefire that would get a majority vote. That's my opinion. It's just an opinion.
Right. But I mean, it raises sort of, so there are 2 questions, I guess, that come out of this. The first goes to, and I think I'm hesitant saying this because it sounds like saying international courts and tribunals are political bodies that take into account extra legal considerations. Right? The point I'm getting to here is that courts and tribunals are aware of their institutional standing and the fact that their ability to give decisions or orders that command the general respect of the international community is kind of contingent on the nature of those orders, which could go to how many judges sign on, and also that question of, are we meeting the needs of the international community in an appropriate way? That sounds all very wordy, but I mean, the obvious thing, I guess, to any international lawyer with a sense of history I'm pointing to is the Southwest Africa cases, right?
Exactly.
So in 1960, the ICJ has several cases put to it about the status of occupied Southwest Africa and the policies of the South African regime there. They essentially come down on the wrong side of history, in part by the casting vote of Sir Percy Spender, an Australian judge at the ICJ, and happily we now have two more after him who can sort of polish Australia's reputation. But for 20 years thereafter, the Global South is just like, well, we're not going to that court. It doesn't represent us. It doesn't represent our interests. It isn't responsive to them. And we don't think it's doing justice to the law. We think it's taking an approach that kind of favors colonial powers. So I think that has always got to be at the back of a court's mind. I suppose one question that I'd invite you to speculate on, and you might just say there's nothing that can be said, it's pure speculation, is that ambiguity kind of worth it to get a few extra judges across the line? Like, I can see that headlines would be different if the decision was 8-7. Like, the headline would be deeply divided court orders Israel to conduct a ceasefire.
Yeah.
But, is it, if you were trying to get 2 or 3 people over the line here, and we don't know, right? We're just assuming that the people with most divergent views appended separate opinions. But if it really is just getting 2 or 3 people over the line, is it worth it? So I guess that's my first question. And the second question is, just to ask you to comment on the bit where any number of commentators have said, well, we had that debate, and then horrific events overtook us, and it's all become irrelevant on any view the order's been breached. So just any reactions you have on those 2 points.
Yeah, absolutely. So I mean, so on the first one, my personal view is that a clearer order would have been better. And it would have been better not just for people who think that a full ceasefire ought to have been ordered. It's actually better for the court, because I think that it's unfair even to Israel to say, there's a bit of unclarity about what it is that you're actually meant to do, and we might hold that against you in the future. I don't think that's in the interests of justice. I think that if you actually want a state to do something, you need to tell them what it is that you want them to do and be clear about that. And I think if we then see a merits order that says Israel has breached this because they continued their actions in Rafah full stop, well, it's kind of difficult to say that is fair. I know that fair is kind of subjective, right? But I think the court, I love this quote from David Luban, right? That the courts bootstrap themselves into legitimacy by the quality of the justice that they deliver. And I think that fairness is really imperative in that, even when you've got states who, for the most part, in general commentary, in the news, in people's personal opinions, might be doing terrible things. The court's job is to be as fair to both parties as humanly possible. And that's how they get their legitimacy, because then you can't say that the court was biased. You can't say that the court had some problem with Israel, and therefore it's, you can't say the court was anti-Semitic or whatever it is, right? So I think that maybe the court has accidentally put itself in a bit of a bind, and inadvertently, by seeking a majority judgment that was really strong, actually undermined itself. Again, that's my very personal view. But like, as you say, events have perhaps made this entire common debate irrelevant, right? Because regardless of whether you think that the military action needs to be limited by this condition or not, what we've seen since then tends to suggest that the order is not being complied with. And I know I'll probably get criticized for saying that, but I think it's true. What we saw on Monday this week, at the time of recording, was horrific, beyond horrific. I mean, it will traumatize people who saw it on the internet, let alone the people who lived through it. And so, yeah, there's this question of going, well, why are we all arguing about this, right? Like, who cares? It's gotten so far beyond what is lawful, arguably. Here's my thoughts. Some people have said South Africa might go back to the court again on the basis of what we saw on Sunday, Monday, and even the rest of this week, where we're starting to see boots on the ground and other activity occurring in Rafah. I actually hope that South Africa doesn't do that, because if we get more orders out of the court that are a little bit ambiguous, that are a little bit unclear, I don't think that's going to help anything. I think the law has done as much as the law can do here. I think the court has done as much as the court can do here. Courts, ironically, Judge Sebutinde is in the minority and she's been criticized a lot. But one of the things that she is right about is that courts are not designed to micromanage conflicts. And courts are there to attribute responsibility, to order reparation, to tell us what the law is. The law is pretty clear here now. And what we need to see now is political actors getting involved. We need to see the other arms of the United Nations getting involved. I kind of feel for the ICJ, right? A huge amount of pressure has been put on them to solve this problem, and it's outside of their power to solve it.
Yeah, look, I think I would agree with all of that. I mean, a couple of points I'd pick up on, looping back to your earlier point. I think your point about fairness is really important. And it was what I was clumsily struggling towards before when I was talking about the institutional standing questions, in that a lot of international law is compared to national law, generally phrased in a bit open textured, right? So
Yeah.
How it's applied, how it's interpreted, that quality of legal reasoning and justification, and that overall sense that what's being done is being done fairly, is enormously important to institutional legitimacy and is the principal means by which courts have of influencing anything. And on the Judge Sebutinde point, and we may come to this I mean, I know you've probably got a couple of questions for me this evening that go in part to this. But I do think there's something to explore in a broader sense about the judicialization of active conflicts.
Yeah.
And I think, terms like lawfare have been thrown around for quite a while, but actually getting courts involved in real time, not after the fact, is quite new, I think, and is an increasing phenomenon that I think we're only going to see more of.
Absolutely. Yeah. Well, look, I think that's actually a really good segue, because I do want to ask you some questions about the other Hague court, which is the International Criminal Court. And in a way, this idea about, how involved should courts be during a live conflict, I think applies here as well, because we've seen the prosecutor say that he's going to seek arrest warrants for 3 senior Hamas leaders and the Israeli Prime Minister and the Defense Minister. And there's a lot of accusations being slung around that the ICC isn't respecting complementarity. So this idea that the ICC is meant to be a court of last resort, because Israel has a functioning judicial system and it could prosecute its own. It just hasn't been given enough time to do so. So, I mean, in your view, like, what's going on here? What's the applicable law? Explain it to me like I'm 5, right? Because I am not a criminal lawyer.
Well, I know plenty of criminal lawyers who would argue that my expertise in international criminal law doesn't make me a criminal lawyer either, but let's do what I can. Okay, so the jurisdiction of the International Criminal Court is actually really poorly understood. So we've all heard the phrase, the ICC is a court of last resort that only acts when a state is unwilling or unable to prosecute its own. That's the thing that comes across in the media and kind of the common sense view of the court. Unfortunately, that statement is a combination of the misleading and the actively untrue.
Mm.
So what we need to do is, do what we're trained to do as lawyers and open a copy of the statute of the ICC and read it. So the relevant rule is the test of case admissibility under Article 17 of the International Criminal Court Statute. And that tells us that the first question to ask is any state actively investigating or prosecuting, and these are the critical words, the same person for the same conduct? If the answer to that question is no, the ICC case is admissible. So on the plain words of the text, there's basically a presumption of admissibility that is rebuttable. Now, the thing is, there are a lot of ways to rebut it. And if you're actually genuinely doing the work, it shouldn't be too hard to rebut it. That's the starting point. Now, the alternative is, the answer is yes. There is an investigation or prosecution going on, not necessarily in the most affected state, could be anywhere in the world. In that case, the ICC may proceed only if, and now we get to the words, the state is unwilling or unable genuinely to carry out the investigation or prosecution. So, for example, in the facts we've got, an ICC case, hypothetically, would not be admissible against Prime Minister Netanyahu for the specific war crime of starvation if there was an investigation or prosecution on foot in Israel against him, not necessarily for precisely the same crime, but at least the same underlying conduct. And there's debate about how close the crime has to be, but the concept is there's meant to be a little bit of wriggle room. Now, you raised the point of time, and a number of commentators have said, oh, but Israel hasn't been given time to launch a prosecution. So in my view, time doesn't come into this at all. It's a red herring, because what you need to activate complementarity isn't a completed trial. It isn't even a trial that's underway. It's just an active and genuine criminal investigation. So bottom line, to invoke complementarity, just open an investigation and show it's being pursued genuinely and with vigor. Now, the problem here is that for whatever reason, and Australia is potentially an example of this, a lot of states would prefer to start with a fact-finding exercise. So in Australia, we didn't leap straight to criminal investigation and prosecution of allegations that the Special Air Services Regiment had committed war crimes in Afghanistan. We had an enormous, very complex inquiry under the Inspector General of the Australian Defence Force, that's generally become known as the Brereton Report. And at the moment in Israel, some are calling for a similar commission of inquiry. But this is the sticker. An inquiry without the power to impose criminal penalties will not satisfy the requirements of Article 17. So if you're saying, oh, wait till we've done a judicial or non-judicial inquiry, but one not connected to a criminal process, and we're going to use that to determine what our criminal process should be, if that's your argument about time, it's not going to work. Now, but the next thing here that's important is, again, cracking open the statute. Once a case has been authorised by the pre-trial chamber, and that hasn't happened yet, the prosecutor must notify the state that would ordinarily exercise jurisdiction. And at that point, a state can say, hey, we're investigating, and raise that argument under Article 18. And at that point, the prosecutor must defer to the national investigation unless authorized to continue by the pre-trial chamber.
Oh.
So, yeah, I know this is not widely known. So that's where you find the fair first bite at the cherry rule.
Yeah.
And we just haven't reached that moment yet procedurally.
Yeah. Yeah, so ironically, the criticism is premature because Israel has an opportunity to say, actually, we are going to investigate this, or the relevant bodies in Israel have an opportunity to say, we will be doing this. And we just haven't gotten to that point yet. So,
right.
Yeah.
And so a number of commentators, so I've seen this from conservative politicians in Australia, I've seen it in the Jerusalem Post in Israel, seem to be talking about complementarity as if it should be some sort of preliminary hurdle, that there has to be an assessment of the Israeli judicial system in general before you can do anything. And that's just not how it works. It's about individual defendants and individual cases. And once those are underway, at that point, the state that might think it's got a better claim to jurisdiction has an opportunity under the statute to say, no, we're doing something. And then you can have the unable or unwilling debate before a pretrial chamber.
Yeah. Yeah. Oh, that makes a lot of sense, actually. So, I mean, really, the system is working. Like one might say, like, this is kind of how it's meant to work, that you've got a prosecutor who's investigating potential crimes under the Rome Statute. The ICC will assess, the basis of those, and then the pretrial chamber will say, no, prosecutor, sorry, actually, we've heard from the state involved, and actually they're going to investigate these themselves, so we're going to back off. It sounds like that's kind of how it's meant to work.
Right. Well, and this goes to sort of something that often gets kind of lost in the traffic, which is we've got this saying, the International Criminal Court was meant to be a court of last resort. Yes, but it was also meant to be a court whose existence would incentivize states to do their own prosecutions.
Mm-hmm.
So I think a lot of the rhetoric here we're seeing is about trying to kick the can down the road, basically because states are reluctant to do their own prosecutions.
Yeah. And so the other thing I wanted to ask you about, because I saw a lot of complaints that the prosecutors' press conference or their announcement, by setting out the case against Hamas as well as the case against Israeli officials in the same breath, if you will, created this kind of moral equivalence between the two. Look, pretty sure, haven't seen those words anywhere in the Rome Statute. But what is your view on this argument that, it's offensive to put, the prime minister of a democracy and the leader of a terrorist organization in the same press conference?
Okay, so this is podcasting is not a visual medium, but Juliette started to chuckle there because I was massaging my temples. So, oh God, spare me the moral equivalence argument. So you've had your moment where you think you're going to get in trouble. Here's mine, rant incoming. Okay, so to make any sense of this, we have to grapple with the internal logic of the argument being made. So as you've already kind of foreshadowed, the first premise is that it is somehow unacceptable that the same announcement of arrest warrants included both Israeli officials and Hamas leaders. So what's the implication of that? I mean, can you imagine what the outcry would have been if the announcement had featured only Israeli officials, right? The same crowd's first reaction would have been, what about Hamas? So that option's off the table. But wait a minute, if we can't name both in the same breath, and we can't name Israel separately, it would seem that the only acceptable outcome for those making the moral equivalence claim would be charging Hamas leaders, but not Israeli leaders, right? That is logically where the argument leads. So in my view, the actual point being made is that international criminal law should only apply to the bad guys and not to our guys. But as we've already said this evening, international law doesn't apply differentially according to whether you believe your cause is just, because everyone believes their cause is just. Now, notably or ironically, Hamas has also objected to being mentioned in the same indictment as Israeli leaders on the same basis. They find the moral equivalency offensive. Now, I do think this does signal an important narrative element of international criminal law. In the wider world, the general public tends to treat international criminal law as distributive of blame. We want it to signal who is most at fault, who the real bad guys are. And I think we can see this particularly acutely in the fact that the International Criminal Tribunal for the former Yugoslavia, and this has been documented in lots of studies, has not actually changed narratives in the Balkans particularly much. National groups praised the tribunal when it was prosecuting the right set of villains and decried it when their people were being prosecuted. So at the end of my rant, the rule of law applies equally to both sides or not at all.
Yeah.
If democracies or our allies or the people we think of as the good guys get a free pass, then that is not the rule of law. That's impunity.
Yeah.
Which is exactly what international criminal law was meant to stand against.
Yeah, that makes a lot of sense. I mean, this is probably the worst metaphor in the history of metaphors, and you may well want to edit it out, but it feels a little bit like that moment when people say, oh, but he couldn't have committed that crime. He was such a good guy.
Right.
The law applies to conduct, and it doesn't matter who did it.
Right.
That seems to be kind of my view. And you can't sort of give someone free rein just because the other guy might be worse.
Right. Or say we can't charge this person at all because I know them to be a good guy.
Yeah.
Which is particularly the kind of classic thing you hear in reports of, just to be as grim as everything else we've discussed, fatal domestic violence homicides, right?
Yeah.
You have all these people suddenly crawling out of the woodwork to say that the murderer was a person of great character. Yeah. Or at the other end of the spectrum, President Nixon allegedly saying, well, it's not a crime when the president does it. We attach these things to conduct, not to status or our subjective kind of determination of whether this person's in our camp or not.
Yeah, exactly.
All right. Well, that's, oh dear. against all of that grimness, let's try and sort of finish on a slightly lighter note. So in wrapping up each of these episodes, I've decided I'd like to ask 3 questions of my co-hosts. So the first of these is, what recommendations do you have for anyone who'd like to know more about what we've discussed today? What are you working on at the moment? And what's your current escape route? What do you read or view or do that takes your mind off international law?
Oh my goodness. So this is going to be the longest part of the podcast. So recommendations for people who want to know more about what we've discussed. I think actually the best thing to do is actually go to the source material. Even if you're not a lawyer and you happen to be listening to this, I think actually it is really worth going to, what did the prosecutor say in his statement? What does the Rome Statute actually say? Because we see a huge amount of spin in the media. And that's not just mainstream media. Any kind of media has an angle that they're trying to put forward. And a lot of commentators try to counter this with objective facts. But I think it's really essential to make sure that you are, if you're interested in these things, going to source material as much as possible and finding objective reports. So, I mean, I prefer to use UN materials wherever possible to, assess facts. And yeah, actually going to, go and read the Rome Statute if that's actually what you care about. Go and read the ICJ statute. It's there in the UN Charter. It got shredded at a thing at the UN Security Council, but less said about that, the better.
Well, we'll be talking in a later episode with Tamsin Page about Security Council shenanigans and what a difficult institution it is and how many crazy and completely unworkable suggestions have been made for its reform. But okay.
I cannot wait to listen to that. That's going to be amazing. But to wrap things up, to answer your on a lighter note, to answer your last 2 questions. So what am I working on at the moment? I'm working on a number of different little pieces that build on previous work that I've done. So for those who don't know, I recently finished my PhD. It was just conferred in March. So I've got various little Douglas clapping.
I don't know how that will come across on the mic, but that's the sound of me clapping. Anyway.
Thank you. It was a labor of love and hate, and let us never speak of it again. But I'm doing a few little projects that kind of come out of some of those ideas, which is all about what are the values which are implicit in procedural choices that courts make about how they're going to govern things. So look out for various journal articles that I'm currently working on. But those are all quite fun. I really enjoy talking about, what are the big picture ideas behind little procedural rules. That's my favorite thing. And look, my current escape route, so I subjected Douglas at the start of this to some K-pop music because that was what was playing when he logged into this session. And that is my escape route, right? And it's super valid, I think, to have something in your life which gives you joy and allows you to switch off a little bit, because huge amounts of what we're seeing is, look, it's intense. I said earlier that, it's going to give people trauma just seeing these images on the internet, let alone deeply engaging with the materials, and God knows, let alone the people who are experiencing this on both sides of the conflict. I think it's not. There have been criticisms at times that to switch off somehow is to neglect or to ignore or to pretend like it's not happening. In no way am I pretending that it's not happening when I stick some K-pop music on and have a dance party in my living room. What I'm really trying to do is give myself enough energy, enough capacity to continue to engage with those materials. So I think self-care is actually really important when you're working in this field. And personally, for me, like smashing out some Stray Kids is the best thing that I could possibly do for my mental health. So yeah.
No, absolutely. And I think there's a phrase that I once appropriated from, I believe, the disability community, rest is resistance.
Yeah.
We cannot be doing the job or fighting particular fights 100% capacity 100% of the time. Can't be done.
Absolutely.
All right. In wrapping up, did you have any final questions for me, including things you've been fed by mutual friends?
Yes. Okay. So this is the question I ought to have probably asked at the start, but as we all know, Douglas is famous online for his excellent sartorial choices. So I would very much like you to describe what it is that you are wearing for our listeners so that they can picture you in your, I have the benefit of a video here, but I would like you to describe what it is that you're wearing so that listeners can picture your excellent clothing choices.
Okay, well, for the purposes of the Zoom call, and it's increasingly late on a Friday evening in Canberra, I've shed my herringbone grey wool jacket, but I am wearing a navy and silver patterned tie, some blue-grey braces or suspenders over a white shirt, and the pièce de résistance is that I picked up from my local tailors today a pair of custom-made grey wool high-waist trousers. And I've got to say, while the criticism is out there all over the internet of people increasingly dressing like their grandpa, as a skinny middle-aged man with an increasing tummy, the comfort of wearing trousers that actually fit, that rise to your natural waist and hang from your shoulders rather than being strapped on with a belt like a tourniquet is a true delight. So I stand by my choices.
Oh, I love it. Look, as Macklemore once said, seriously, can I have your grandpa's clothes? I think that's amazing.
Look, Juliette, it's been a blast. Thank you so much for being part of this first episode and part of the core team. I look forward to speaking with you again, probably in sort of around 4 weeks.
Absolutely. It's been a blast. Thank you so much for having me.
Oh, thanks so much for being involved.